Tell you that a bill seeking to empower the Nigerian Bar Association (NBA) to remove corrupt judges through a non-confident vote scaled a second reading in the House of Representatives. Sponsored by Afam Ogene, a member of the Labour Party LP representing Ogbaru Federal Constituency of Anambra, the bill aims to alter sections 231, 238, 250, 256 and 271 of the 1999 Constitution, which deal with the procedure for the removal of judges. The bill seeks to confer powers on the NBA to receive petitions against any erring judicial officers, consider the defense of the petitioned officer, and if not satisfied, conduct a confidence vote. To help put this into perspective, we're joined by legal practitioner Bayo Sanni. Mr. Sanni, thank you so much for joining us.
Thank you for having me here.
I have to say, a bill seeking to empower the Nigerian Bar Association to remove corrupt judges through a non-confidence vote, it seems to be laudable. What's your take?
It is laudable. As a lawyer, as a legal practitioner, it is laudable. And sincerely, I think I pray that that bill makes it, scales all the orders and becomes law in Nigeria. Why do I say this? We will look at it from the legal point of view, and we will look at it also from how the common man on the street will view it and the effect it will have on the judicial system and our democracy as a whole. Now, this is the right procedure that they are following now. They're taking the bill through the National Assembly to amend previous provisions in the constitutions that makes, the constitution that makes it cumbersome kind of for the removal of corrupt judges. They are human beings. They can run foul of the ethics of their assignment, and that does not mean that they are above the law. There's no immunity. But in the case where the existing law is that the governor or the president will have to send the petition to the NJC, NJC will have to, they have to wait for two-thirds majority from the House before such judge is removed. You understand? That was what EFCC could not wait for during President Buhari's administration, when DSS invaded some judges and the apartments of some judges on grounds of corruption and all that. We saw how that played out. So, but in this situation now, they are now getting the stakeholders involved. Who are the stakeholders? The lawyers. We appear before these judges every day. We have our complaints about them. You understand what I'm saying? If there's anybody or if there's any group of people that can tell you that this is the true position of things with respect to the performance of a judge and the ethically, or the uprightness of a judge on the bench, this is the lawyer that appears before that judge every day. So they are now bringing us on board. We are now stakeholders, and we'll be able to have a say in that process. That's a very good bill. It's laudable. And
if it passed through the second reading and then goes to be signed into law, we have to make sure that it is safe, fail-proof. It has to be safeguarded. And so I have to ask you, what safeguards would be needed to be included in the bill to prevent any potential misuse of vote of no confidence mechanism to whether to influence or even intimidate the judges, because we have to also be fair to the judges as well.
If you look at the content of that bill, they are looking at that vote of no confidence to be passed at the annual general meeting of lawyers. Okay, and just as they are bringing us in, like you rightly asked, they say it so that they don't misuse that law, we don't abuse it too. We are talking about, when it comes to the annual general meeting, we are talking about gathering of over 5,000 lawyers. They all cannot be wrong. And it's a vote of no confidence, the absolute majority of all that place, of all those people, all of them cannot be wrong. That is number one. Number two, I also feel that there are some technical issues they should also look into. It shouldn't just end there from vote of no confidence. We can't just rise from annual general meeting and say you have been so removed. You understand? There should be opportunity for the judge to defend himself too. Hear the other side. That's a major legal principle, or the autem patent in law. Before you sentence somebody, before you convict somebody, you hear the other side. So there should be room for fair hearing here. We can't just go to our general meeting, pass no vote of confidence, vote of no confidence on the judge, and from the content of that bill, it says that once the vote of no confidence has been passed, the judge is deemed to have resigned from office, we shouldn't leave it at that. We should give room for fair hearing. Such judge should be given opportunity to defend himself. Okay, these are the issues that have been presented before you. So it is the response of the judge that should be considered at that particular meeting before the vote of no confidence is passed. If we say that they should now create another committee to look into that situation, we are just creating unnecessary bottlenecks. But if a vote of no confidence has been, if the proper position, maybe within MBA a meeting, the committee should be set up to look into that, and that committee should be all-encompassing. It shouldn't be just few people, some radical group of people. We should carefully selected people with open mind and unassuming people that can really look into it.
Unassuming and carefully selected people with open mind. But let's also talk about ensuring that the judiciary remains free from undue political interference. This has become the most like a core part of our political narrative in a couple of months, or maybe in the last 1 year, where we've been talking about autonomy, full autonomy for judiciary, the third arm of our government. How can the bill then ensure that this happens, that the judiciary remains free from undue political interference while still addressing the concerns of corruption?
This bill will not address that.
You think so?
From the content of the bill, this bill focuses more on the removal of the judges. Autonomy is another constitutional issue, which I believe that this House of Assembly should really look into. Or perhaps we can solve it by the judicial process that was done for the local government. You understand how we got the autonomy of the local government. They went to the Attorney General of the Federation, had to take the 36 states to court for the Supreme Court to make pronouncement on that. Perhaps that's what we're doing. But this bill is, from the content that I have seen, is not looking at curing that. And we cannot really save the judiciary from the grip, on the political grip of the executive, if we do not have full autonomy of the judiciary. So, and it has scaled to second reading. I don't see any amendment coming in to give room for what you have asked now, so that we can also look into it. But sincerely, except if we want to deceive ourselves, has the Constitution not given judiciary autonomy? We are just creating we are just creating a farce out of this fiscal policy of them not getting their funds. At the federal level, the federal government has come to tell us that the federal judges enjoy autonomy, not at the state level. So if the federal judges are enjoying autonomy, why can't the state judges enjoy autonomy? Are they not deriving that same authority from the same instrument, which is the Constitution? The
watchdog for the judiciary is NJC, the National Judicial Council.
Yes.
If this passes past second reading and now goes through to be signed into law, what happens to the NJC in this situation?
That is the concern that some people may have, that it whittles down the powers of the NJC for removal and appointment. But it doesn't. I don't see it that way. It just creates an alternative for us.
So checks and balances?
Checks and balances. Presidents and governors still have their own way. The governors of the 36 states and the president of the Federal Republic of Nigeria will still have his own way, or their own way of removing judges through the NJC. But this time around, we are widening the gap. Do you understand? We are widening the gap. We shouldn't narrow. We can't have an unfit, I'm sorry to use that word, somebody with questionable character sitting on the bench. The lawyers are appearing before that fellow, and their hands are tied. They can't even be part of the process of removal of the. They have to still present their own petition to the NJC. And don't forget that in every state, the chief judge of every state is the head of that NJC of that state. They are members of the National Judicial Commission. The chief judge of the federation is the head of the NJC in Nigeria. That's the how should I put it now? The highest officer there. Still the same chief justice of the federation, of the National Judicial Commission. Chief judges of each state, they are members of this NJC, and we're talking about their learned brothers here. So it still comes down to another legal principle that you cannot be a judge in your own case. Same learned brother, you're bringing a case against it. Look, we are human beings. We shouldn't rule out interactions. We shouldn't rule out relationship.
Right.
They can go emotional about this thing and not say it the way you are saying it.
So to be in sync and synergy. Mm-hmm. Although the NJC is still a watchdog, this is necessary.
This is necessary
to curtail over extension of the judiciary, but most importantly to curtail because at the end of the day, the lawyers are the ones on the bench. They're the ones who know for certain the judges and how they rule. And also, this will help to set precedents if this goes into law.
We should also look at it from one. I want to lay emphasis on one point there.
Okay.
They are not trying to whittle down the powers of the NGC. They are bringing in the stakeholders into the process.
Right.
Yes.
Well, Mr. Sanni, I have to say thank you so much for taking out the time to join us today. Thank you very much. Mr. Bayo Sanni, he is a legal practitioner, giving us a bit of insight following the rule, or rather the second reading, or rather the bill that's been passed for second reading, that the NBA will now have autonomy, or should I say a vote of no confidence, to vote for judges that they deem corrupt.